Nicholson did exactly the same thing.
I'm aware.
It should not happen.
My profound apologies. It was entirely unintentional.
Chair, may I just say, and I'm sorry to do this whilst my learned friend is now on her feet, but the fact that I've had to object has itself now drawn attention to something potentially. And so my client's rights are now really being prejudiced because, and I make no statement about Ms. Hassan, who is a consummate professional, and I fully accept it might have been an accidental slip. But even the fact that I've had to record the objection now elevates the issue and creates the very damage that we've tried to protect my client from. And I'm in an invidious position where I am where I am. And so I would ask, Chair, not that you can control the media or anybody else, but just to remind people about their responsibilities in what they say publicly regarding the impact that can have on the dignity and privacy rights of someone who's made an express claim for confidentiality to avoid this exact situation. And I'm sorry to interject my learned friend while she's on her feet, but I have to now place this on record as a matter of principle that we're heading into dangerous territory.
Thank you, Mr. Premheed. For now, let's leave it at the point that I have made, the admonition that I have made, and let Ms. Hassan continue.
Thank you, Chair, and I do reiterate my apologies. It was entirely unintentional. It's difficult to take out from one's head all of the information we've been looking at and reading and dealing with over the last few days. What I wanted to say was that the point of putting up the evidence on the movements is not to disprove any diagnosis, not to use it to challenge the clinical findings of a treating doctor. But it is important because what it does is it bears directly on Mr. Carrim's demonstrated ability, his day-to-day functioning capacity. That's what the movements go to. And it also goes to something else, which is, and I'll come to it later, it's about the reliability and completeness of the information that was before the treating doctor at the time when he deposed to the affidavits that we now have in this application. So that's the relevance of the movements.
Are you saying, because the issue as I understand now is about flighting or not flighting?
That's right. So
are you saying you require flighting for purposes of what you've just explained?
No, Chair, it was just a preliminary point to explain why we go here at all, that it's not simply for the purpose of showing that Mr. Carrim was in fact in Durbanville on the 14th of July. It's not merely for that fact. It's more than that. But I can continue to make my submissions to the second point that I'm raising about day-to-day functioning without flighting the footage. I will make that.
That's exactly how I understand it. I do not see what stands in your way to make those submissions without flighting. I simply do not understand. But as you say, you've just said now, you are able to make those submissions. So
I'm perfectly...
Yes.
I don't need to rely on the footage in order to make those submissions.
Yeah.
And
because there's the admission by Mr. Carrim through the deponent, his wife, that he was indeed in Durbanville and at this particular shopping center, that he went to Woolworths and this other place. I can't pronounce that name starting with a K, with many vowels in it.
Why? So I'm going to talk about that evidence, but I don't need to flight the actual CCTV.
Thank you. So that takes care of Mr. Premheed's one of Mr. Premheed's 2 points.
I think both, because we also have no objection to the redactions.
All right. Thank you. Thank you. There was what was the third thing? Oh, yeah, there was an issue about the geolocations.
Oh, yes. I think in the context of the sensitivity of what we're dealing with. And perhaps, Chair, I should just refer to the ruling that you made yesterday, because that's the constraints that are governing my ability to make submissions to you candidly. So the ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand
Please.
why we're talking in this coded way. So paragraph 2.1 says the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Carrim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Carrim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Carrim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Carrim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Carrim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the Chair?
Why not use the first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right. So I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Carrim will be incapacitated has varied and grown each time. So in the beginning, it was a few weeks, then it was 8 to 12 weeks, then it was 6 months. In the latest latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the fifth postponement that Mr. Carrim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Carrim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle. And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Carrim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that we have now received the further medical report. This report is highly personal. Suffice to state that our client has been laid off for at least 8 to 12 weeks, and that was all. No medical certificate or report or note or anything accompanied this. It required requests from the attorneys for the commission to obtain the necessary medical report to underpin the postponement request that was made. So that's the history that we're dealing with here, which is why the evidence leaders feel so strongly that getting finality and a specific date is so critical. We then come to the latest. I'd rather go to the most recent history on the postponements. The last postponement was to 15 July. Up until that point, all of the postponements were granted, were permitted on the understanding by the commission and the evidence leaders that Mr. Carrim was hospitalized and that his movement was restricted. That's what we were led to believe. It was only when there were the two whistleblower reports on the 14th of July that the issue of Mr. Carrim's movements were put into question. The evidence leaders then obtained the CCTV footage to corroborate what we'd been told by the evidence, by the whistleblowers. Mr. Carrim was then afforded the opportunity to bring a substantive application for the postponement. And in that application, an opportunity was provided to address the latest information regarding Mr. Carrim's movements around the Cape. And this is addressed in two affidavits. The one, as we've already been talking about, is by his second wife, and the second affidavit is by his doctor. What what we were told in those affidavits is important. Their accounts, and I'm not going to go into the detail, it's summarized at paragraphs 39 to 44 of Ms. Berger's answering affidavit. What we saw there was a particular picture that was painted by the two deponents, and particularly by Mr. Carrim's doctor. That picture was one of restrictions on Mr. Carrim's movements and interactions. We were informed that any leave from the hospital would be authorized for specific purposes, that there were passes that were subject to strict conditions, including searches, etc., including on the return of the 14 July excursion, which was said to have been a 4-hour chaperoned excursion that took place between 1:30 in the afternoon and 5 p.m. in the afternoon. That was the account that was provided by their doctor. It was supported by Mr. Carrim's wife. Now, it's important, commissioners, to go to those affidavits. So let's look first at what Mr. Carrim's wife says, and that's at paragraph 60 of the founding affidavit. If I could ask the commissioners to read paragraph 60 and its subparagraphs, where the 14 July incident is explained. I'd like to place emphasis on 60.2, where it says we departed the facility at 1:30. Then 60.3 and the description of the Kauai engagement. 60.4 and 60.6. Specifically where it says we returned to the facility by approximately 5. And then there was a consultation, but they both, I've emphasized the word we in 60.6, attended. In paragraph 73 of the same affidavit, the deponent summarizes all travel since 13 April 2026. And I draw your attention to paragraph 74, where the deponent says, my husband undertook no other travel during this period and did not travel to Mahikeng or any other location in the Northwest. There's a second affidavit, which I'm going to come to, in which this is a different picture is painted. And what the deponent says later is that that trip to the Northwest took place during the week when Mr. Carrim is with his first wife. And so, says the deponent, she did not know about the trip, and that's why she didn't say anything about it. What my submission on that is that that's implausible when we have regard to her own evidence that she communicates regularly with the first wife, and you'll see that at paragraph 15 of her.
It draws a point to say that the medical doctor's observations who's treating Mr. Carrim have a central role to play in any determination in how Mr. Carrim is treated. And we would say that the evidence speaks for itself and it's unchallenged in front of you. But there are a few more things I'd just like to say in that regard, if I may. The first one is, our learned friends provided us a bundle of authorities. A lot of it is foreign authorities.
But before you go to authorities,
Yes, Chair.
I think the first point that doctor makes, that is Mr. Carrim's, is that, and I'm going to an assessment by an independent doctor. So Mr. Carrim's doctor says such an assessment, in fact, I think the doctor uses the word interpositioning. So if another doctor is interposed, that will be deleterious to the treatment that Mr. Carrim is undergoing.
Correct.
So the first point or the first prize is that no other doctor should be interposed. But as I understand it, your expression seems to suggest that I'm misunderstanding the situation. But let me continue. You will respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
I know. Then the second point, as I understand it, is that if, despite my opposition as the doctor, as the treating doctor, if despite that the position is that another doctor should be interposed, that should be done in, I'm paraphrasing here, forgotten the actual wording, that should be done in consultation with me. I should be involved. As to how exactly, I'm not altogether sure now, should be done in consultation with me. Now, what I wanted to raise is, if the doctor does say that as an alternative, would Mr. Carrim oppose this? That is the alternative. Would Mr. Carrim totally oppose it?
Well, I have no instructions on that. And as you know, the legal team have had to obtain instructions.
No, in the manner in which you and I know, yes, how this is.
So I would have to take an instruction. But if I may, I don't know if you are done, Chair, and I don't want to interrupt you.
Yes,
but
yes.
Having regard to my facial expression earlier, the reason that it was of that kind is, if you can go to the paginated pleadings, please, paginated page 49.
Yes.
If you look at the heading just above paragraph 68, the consequence of compelled attendance. So I think how I understand the treating doctor's position is this. And I think, Chair, this goes back to the debate you and I had last time. And can you draw any inference from a compelled attendance where it's chosen not to attend or a voluntary attendance? The position of the doctor is that it's not to say that none should be interposed as a blanket position. It's to say none can be interposed unilaterally or in a compelled sense that the doctor resists. And then the doctor's position in respect of what then? So in other words, if it's voluntary, does it come through me or whatever?